Let's talk a bit about the patent process. So once we've determined that what you have is novel, is non-obvious, and is worthy of a patent, the way to enter the patent process and actually start the road toward getting a patent is to file a patent application. Before we can file a patent application, what we need to do is prepare a patent application. Now, preparing a patent application means really getting together what the invention is, what's different about the invention, and why it's worthy of a patent in the form of a document, which can be 20, 30, 40 pages in length. But the point of it is to begin the process of convincing the patent office to grant you the patent. So filing the application is the first official step in the patent process. Now, all patent applications aren't created equal, because if you're looking to protect your idea, you're really hanging all of your hope on the strength of this patent application. So a poorly written patent application can sometimes even result in a patent, but not a patent that you could use to stop people from stealing your invention. Because a patent application is only as good as it is well written. And the priority that it establishes for you as the first inventor of this product is only as good as it is well expressed in that patent application. There's a high degree of criticality to how patent applications are written. And I'm a patent attorney, so it would seem natural that I would say that you need a patent attorney to write a patent application, but it's simply the truth. You know, while there might be elements of this process that you can do yourself and that you should do yourself, writing a patent application is the most critical, the most technical, and requires the most skill of anything in this entire process. And it is the most important thing, then, that the patent application be done correctly and done fully understanding what your invention is, fully understanding what's distinct about your invention, fully understanding where you're headed with this invention, so that the patent that you end up getting is perfectly appropriate for what you need. And it all comes down to the patent application. Assuming that your application has been prepared and is everything that it needs to be, we file it with the United States Patent Office, and on the day that it's filed, it becomes patent pending. And I'm sure that you've seen products marked patent pending, and basically what that means is that the application has been filed, and the inventor is waiting for the patent office to review and grant the application. So now, when you're in patent pending status, it becomes a little bit of a waiting game as far as the patent itself. What you're waiting for is examination. Examination is where your application gets assigned to a government examiner whose job is to review your application, do their own prior art research, do their own comparisons, and make their own judgment of whether your invention fits the criteria for patentability. Now, assuming the review by the patent office examiner is favorable, then they'll issue what's known as a notice of allowance. And when a notice of allowance is issued, the patent office is essentially saying you've been approved. And once you pay certain issuance fees, then the patent will be granted. On the other hand, sometimes the examiner's review isn't that favorable, and they might initially reject the application. And if they do reject it, though, they have to give us reasons why it's been rejected. And once they give us the reasons why it's been rejected, we could look at it and determine whether it's rejections we could overcome. And most of the time, through my career, I found that the majority of rejections can be overcome, and probably even more than that, is where there might be a decent probability we get an initial rejection. Once we have the opportunity to actually show them that the rejection should not have been issued, which we do in writing with the patent office, then typically the examiner will remove the rejections and give us a notice of allowance so that we could then have the patent issued to us. So those are the main points of the patent process. And once the patent is issued, then you have the right to exclude other people from making, using, or selling the invention within the United States. And this is a right that you could keep to yourself, you could sell to someone else, or you could license to a company who wants to make that product. So at this point, you should have a pretty good idea of what the patent process is all about and what you need to know before getting into this process. So in the next video, I'm going to share with you some of the common concerns that many of my clients had prior to working with me.